On November 24, 1942, the National War Labor Board issued General Order No. 16. It was 3 pages long. It authorized employers across the United States to pay women the same wages as men for comparable quality and quantity of work. There was no constitutional amendment, no decade-long legislative fight, just a wartime administrative order, typed and filed and implemented within weeks. Equal pay, it turned out, was never an impossibility. It was a policy choice. And the moment the war ended, the government made the opposite choice, just as quickly, just as deliberately. But that order in 1942 didn't come from nowhere. It arrived into a legal system that had spent the previous 4 decades building, reinforcing, and defending the principle that women's labor was worth less than men's. Not as a side effect or an oversight, but as a foundational legal doctrine, argued before the Supreme Court, encoded in federal policy, and enforced industry by industry across the entire American economy. The question isn't why the wage gap existed. The question is who designed it and what exactly they were protecting. The answer starts in Portland, Oregon, in 1903. A man named Kurt Muller owned a laundry. One of his overseers required a woman named Mrs. Elmer Gotcher to work more than 10 hours on September 4th of that year, violating an Oregon statute that limited women's working hours in mechanical establishments, factories, and laundries. Muller was convicted and fined $10. He appealed. The case climbed through Oregon's courts and reached the United States Supreme Court in 1908, where it became one of the most consequential labor decisions in American history, not because of what it said about working hours, because of what it said about women. The court ruled unanimously to uphold Oregon's law. The opinion, written by Justice David Brewer, declared that a woman's physical structure and a proper discharge of her maternal functions justified the state in treating her differently from men under the law. Women were, in the court's language, a special class. Their bodies were weaker, their social role was motherhood, and because of these biological and social facts, the state had a legitimate interest in limiting, shaping, and regulating their participation in the labor market in ways that would never be applied to men. The case was Muller versus Oregon, and it split the women's movement for decades. Some reformers, particularly those in the National Consumers League who had helped bring the case, embraced protective legislation as a genuine shield for vulnerable workers. Others saw it for what it was. The legal scholar Pauli Murray would later describe these protective statutes as a roadblock to the full equality of women. Both sides were right, in a sense. The laws did limit exploitative hours. They also established, at the highest level of American jurisprudence, the principle that women's relationship to work was categorically different from men's. And once that principle was established in law, it didn't stay confined to working hours. If a woman was a special class of worker, if her labor required special regulation because of her body and her presumed destiny as a mother, then it followed, in the logic of the time, that her labor was worth something different too. Not merely that employers could pay her less, that the state itself could set a different price on her work. This is the step most people miss when they hear about the wage gap. They imagine individual employers making individual choices, driven by prejudice or market forces. But what happened in the early 20th century was structural. The legal reasoning of Muller versus Oregon didn't just permit wage discrimination, it provided the intellectual scaffolding for governments to mandate it. That scaffolding held for 25 years without much strain. Then the Great Depression hit, and the federal government, for the first time in American history, began setting wages directly. The National Industrial Recovery Act of 1933 was Franklin Roosevelt's first major attempt to stabilize the collapsing economy. It created the National Recovery Administration and empowered it to establish industry-wide codes of fair competition. These codes set minimum wages, maximum hours, and working conditions for entire sectors: steel, textiles, lumber, retail, manufacturing. Hundreds of codes covering millions of workers. And embedded in code after code, sector by sector, was a differential. Women's minimum wages were set lower than men's. This wasn't hidden. It wasn't a loophole exploited by clever employers. The NRA codes explicitly established 2 wage floors, one for men, one for women, performing the same categories of work in the same industries. The principle from Muller versus Oregon had migrated from working hours into wages, from state law into federal policy, from judicial reasoning into administrative code. A woman working in a textile mill governed by an NRA code wasn't being underpaid because her employer was biased. She was being underpaid because the United States government had determined in writing that her labor was worth less. The NERO was struck down by the Supreme Court in 1935, but the codes had been in force for nearly 2 years, and their logic outlived them. The wage differentials they formalized didn't disappear when the law did. They had given official sanction to what employers were already doing, and that sanction proved remarkably durable. Decades later, in 1974, The Supreme Court itself acknowledged this legacy in Corning Glassworks versus Brennan, noting that the American wage structure had long been based on an ancient but outmoded belief that a man, because of his role in society, should be paid more than a woman, even though his duties are the same. Ancient, outmoded, and in 1974, still operational. That's what it means to say the gap was built. It was built the way you build any infrastructure, layer by layer, with legal foundations supporting economic structures, supporting cultural assumptions, until the whole thing looks natural, until it looks inevitable, like gravity. But it wasn't gravity, it was a blueprint, and you can trace its lines through the specific mechanisms that employers use to implement it on factory floors and in office ledgers across the country. Consider the textile mills of Lowell, Massachusetts. By the late 19th century, these mills employed thousands of workers, men and women, often performing physically similar tasks on similar machinery. The work itself didn't change based on who was doing it. A loom operates the same way regardless of the operator's gender. Thread doesn't know who's guiding it, but the pay changed dramatically. Women in these mills earned between 40 and 60% of what men earned, and the mechanism that made this possible wasn't crude. It was bureaucratically elegant. The key was job classification, not job description. An employer didn't need to argue that women were less productive, or less skilled, or less reliable. They didn't need to make any argument about the work at all. They simply created two categories of title for what was functionally the same role. When a man did the work, he was an operative. When a woman did the same work, on the same equipment, producing the same output, she was a helper, or an assistant, or a learner. The title was different. The pay scale attached to that title was different. And because the pay followed the classification rather than the task, the entire structure looked rational on paper. You weren't paying women less for the same work. You were paying helpers less than operatives. That these categories mapped perfectly onto gender was, officially, a coincidence of hiring patterns. This wasn't unique to textiles. The Carnegie steel supply chain, the garment industry, food processing, cigar manufacturing, all of them used variations of the same technique. The genius of it, if you can call it that, was its invisibility to anyone who only read the ledger. The books balanced. The pay scales were internally consistent. Every worker was paid according to their classification. It's only when you walked the factory floor, watched the actual work being done, and compared the tasks performed by operatives and helpers side by side that the lie became visible. And someone did walk those floors. Carroll Wright became the first U.S. Commissioner of Labor in 1885, and he was, by the standards of his era, genuinely committed to documenting the conditions of American workers. His 1885 report for the Massachusetts Bureau of Statistics of Labor was exhaustive. His subsequent federal studies, including the 1889 report Working Women in Large Cities, provided some of the first systematic data on what women actually earned relative to men across industries and regions. Wright counted everything. He documented the hours, the wages, the conditions, the occupational categories. He quantified the gap with a precision that no one had attempted before. Women in manufacturing earned, on average, roughly half of what men earned, in some industries closer to 40%. The numbers were there, in black and white, in government reports, published and distributed. But here's what Wright didn't do. He didn't challenge the structure that produced those numbers. His reports presented the wage gap as a factual condition of the industrial labor market, something to be measured and cataloged, not something to be questioned or dismantled. The data normalized the gap by treating it as an outcome to document rather than an injustice to explain. When future policymakers and employers cited these reports, they could point to them as evidence that the gap was simply how the economy worked. It was a feature, not a flaw. Look, even the government's own statistician recorded it without alarm. This is how systems sustain themselves, not through a single act of villainy, but through measurement without judgment, documentation without challenge, expertise that describes the world as it is and never asks whether it should be different. Wright wasn't a villain. He was a careful researcher operating within the assumptions of his time. But his careful research gave the system a patina of scientific objectivity that made it harder, not easier, to resist. And women did resist. They resisted early, and they resisted often. The mill workers of Lowell had been organizing since the 1830s, staging turnouts, their word for strikes, when wages were cut or conditions worsened. But by the late 19th century, when the classification system was fully entrenched, women who organized faced a specific and vicious form of dismissal. Their collective action was characterized by one mill manager as an Amazonian display, a spirit of evil omen. Not a labor dispute, not workers exercising bargaining power, but an unnatural spectacle. Amazons were mythological. Evil omens were supernatural. The language told women that their organizing existed outside the boundaries of rational economic behavior, that it was hysterical, dangerous, something other. This framing mattered because it determined who was taken seriously in negotiations, in courts, in legislatures. A male worker organizing for higher wages was engaged in labor relations. A female worker organizing for the same wages as the man beside her was engaged in something disruptive to the natural order. The classification system on the factory floor had a mirror image in the cultural classification of women's economic demands. Both systems used naming to determine worth. So by the early 20th century, the architecture was complete. Legal precedent from the Supreme Court established that women were a special class whose labor could be regulated differently. Federal codes during the New Deal formalized lower wage floors for women by sector. Employers used classification systems to maintain the gap at the firm level without ever having to state openly that they were paying women less for the same work. And government statisticians documented the result without questioning the cause. Each layer reinforced the others. Each layer made the next one seem natural. And then, in December 1941, the United States entered World War II, and within months, the entire structure bent. It didn't break. That distinction matters. But it bent further and faster than anyone involved would have predicted, because the war created a condition that peacetime economics never had, an absolute non-negotiable need for labor that could not be filled by men. 16 million Americans eventually served in the armed forces. The factories that supplied them needed workers, and the women who filled those roles didn't just enter peripheral positions. They entered manufacturing, shipbuilding, munitions production, welding, riveting, electrical work. Approximately 6.6 million additional women joined the workforce during the war. The share of manufacturing jobs held by women rose from 21% in 1940 to 34% by 1944. These women weren't doing helper work, reclassified by title. They were doing the jobs men had done, on the same lines, with the same tools, producing the same output. And this created a problem. Not a moral problem, as far as the War Labor Board was concerned. A structural one. If employers paid women less for these jobs during the war, then when men returned from the front, employers would have an economic incentive to keep the women and their lower wages, rather than rehire returning veterans at higher rates. Equal pay for women during the war wasn't feminist policy. It was veteran protection policy. That's why General Order No. 16 existed. When the National War Labor Board issued it on November 24, 1942, it authorized employers to voluntarily adjust women's wages to equal men's for work of comparable quality and quantity. The language was careful. It said voluntarily, and it said comparable. Not mandatory, not identical. The board wanted to prevent the worst cases of wage depression without requiring employers to restructure their entire compensation systems. And implementation was exactly as inconsistent as that cautious language would predict. Employers who wanted to comply, complied. Employers who didn't found ways around it. The most common tactic was familiar: reclassification. A job performed by a woman in a munitions plant could be labeled light work, as opposed to the heavy version a man had done. Same task, same output, different adjective, different pay. The classification trick that had worked in the textile mills of the 1880s worked just as well in the shipyards of the 1940s. The technique was portable because the underlying logic hadn't changed. Women's work, by definition, was lighter, easier, less valued. But even with these evasions, the wartime economy brought women's wages closer to men's than they had been at any point in American history. For roughly 4 years, in the industries covered by War Labor Board oversight, the gap narrowed visibly. It narrowed because the country needed the work done, and it needed it done without creating a structural disincentive for returning soldiers. Equal pay was a tool. It served a purpose. And when that purpose expired, so did the policy. The war ended in August 1945. What followed was not gradual. Women were dismissed from manufacturing jobs immediately and systematically, not reassigned or offered alternative positions. Their jobs were held for the men coming home, and the women who had performed those jobs for 4 years were expected to vacate them without protest. By the spring of 1946, female labor force participation was plummeting back toward pre-war levels. The factories that had recruited women with patriotic posters and government-sponsored childcare now showed them the door. And wages followed. The classifications reverted, and the pay scales readjusted. Within 18 months of the war's end, the brief wartime experiment in near equal pay had vanished from most covered industries, leaving behind only the proof of what it had demonstrated. Equal pay was administratively simple. The government could mandate it when it chose to. What the war proved, more than anything else, was that the gap wasn't natural. It wasn't the result of market forces operating on genuine differences in productivity. It was a choice made by employers and ratified by government, and it could be unmade in exactly the same way. The wartime experience made that argument impossible to deny. The Michigan Supreme Court had said it plainly in 1940, just before the wartime experiment began. It is a matter of common knowledge that there are great numbers of women employed in manufacturing and that many employers pay their women employees less than they pay their men employees for identical work. Common knowledge, not controversial or disputed. Everyone knew. The war just made it visible in a new way, because for a few years the gap disappeared, and nobody's productivity collapsed, and no industry failed, and the only thing that changed was that women got paid what the work was actually worth. Then 1945 came, and the country decided that was enough of that. Equality had served its purpose. The men were home. The wartime utility of fairness had expired, and with it, the willingness to maintain it. So by 1946, American women were back where they started. The legal architecture from Muller versus Oregon still stood. The classification systems from the industrial era were fully operational. The brief proof that equal pay was possible had been filed away as a wartime anomaly rather than a peacetime precedent. And the question that hung over all of it, the question that would take another 17 years to even partially answer, was deceptively simple. If the government could mandate equal pay during a war in 3 pages of administrative order, what would it take to mandate it during peace? The answer, it turned out, was not 3 pages. It was not an executive order signed in wartime urgency. It was 18 years of bills introduced and killed, reintroduced and killed again, watered down and still killed, revised and resubmitted, and sent to committees that never scheduled hearings. 18 years of women testifying before congressional panels, presenting evidence, citing the wartime precedent, and being thanked politely for their time before the session adjourned. The first person to try was a Republican from Buffalo, New York. Winifred Stanley was a lawyer, a former assistant district attorney, and in 1943 she became one of only 9 women serving in the United States Congress. She'd watched the war reshape the workforce. She'd seen 6 million women walk into factories and shipyards and prove, conclusively, that the work got done. And in June 1944, while the war was still being fought, she introduced H.R. 5056, a bill to make wage discrimination based on sex and unfair labor practice under federal law. Stanley's argument was straightforward. The war had demonstrated something that could not be undemonstrated. Women were performing the same jobs as men, in the same facilities, with the same output metrics, and the only reason they'd been paid less before the war was that employers could get away with it. She put it plainly on the House floor. It has often been remarked that this is a man's world. The war and its far-reaching effects have provided the answer. It's our world, and this battered old universe needs and will need the best brains and ability of both men and women. The bill went to committee. It did not come out. Stanley lost her re-election bid in 1944. She returned to private law practice in Buffalo, and her bill died with the session. But the coalition she'd begun to assemble did not die with it. 3 groups, each with different politics and different memberships but overlapping on this single issue, would keep equal pay legislation alive through the Truman years, through the Eisenhower years, through the early Kennedy administration, bill after bill after bill, session after session after session. They were the Women's Bureau of the Department of Labor, which had been documenting the wage gap since its founding in 1920. They were the UAW Women's Department, led by Caroline Davis, who brought the specific grievances of industrial workers and the organizational muscle of the largest union in the country. And they were the National Woman's Party, the organization founded by Alice Paul, which had been pushing for an equal rights amendment since 1923 and saw equal pay as one front in a larger war. These 3 groups did not always agree on strategy. The Women's Bureau favored protective legislation. The National Woman's Party wanted constitutional equality. The UAW worked through collective bargaining, but between 1945 and 1963, they formed an informal relay, passing the issue back and forth, keeping it on desks, keeping it in hearing rooms, keeping it from disappearing entirely into the vast congressional machinery designed to quietly suffocate legislation. Nobody powerful wanted passed, and nobody powerful wanted this passed. The opposition was not crude. It rarely argued that women deserved less money for the same work. That argument had become, after the war, politically embarrassing to make out loud. Instead, the opposition spoke in the language of economics. Government-mandated wage floors would distort market forces. If women could be hired for less, that reflected the market's efficient allocation of labor. Intervene, and you would create unemployment among the very women you claimed to help. Employers would simply stop hiring them. The invisible hand apparently had strong feelings about gender. This argument carried a specific power. It sounded neutral. It sounded like science. It framed equal pay not as a moral question, but as an economic one, and on economic questions, the experts could disagree endlessly while nothing changed. The same rhetorical move that Carroll Wright had made in the 1880s when he documented the gap with statistical precision while treating it as a natural phenomenon was now being deployed in hearing rooms on Capitol Hill. The gap was acknowledged, and its persistence was reframed as evidence of its own legitimacy. Between 1945 and 1963, equal pay bills were introduced in nearly every session of Congress. They were introduced by Democrats and Republicans in the House and the Senate, with language that shifted slightly each time, trying to find the formulation that could survive committee. They accumulated co-sponsors, generated testimony, and produced reports. And then they died. Not in dramatic floor votes with passionate opposition speeches, but in committee, without hearings, or with hearings that produced no markup, or with markups that produced no vote. They died the way most legislation dies, which is to say quietly, bureaucratically, and in a manner that allows everyone involved to claim they supported the principle while ensuring the principle never became law. What changed, finally, was not the argument. The argument had been won in 1944, maybe earlier. What changed was the political configuration. John F. Kennedy took office in January 1961, and he appointed Esther Peterson as Assistant Secretary of Labor and head of the Women's Bureau. Peterson was a former union organizer, a veteran of the labor movement, and she understood something about legislation that the coalition had learned over 18 years of failure. You did not pass a bill by being right. You passed a bill by being useful to the people who controlled the calendar. Peterson worked the committees. She built the specific coalition of votes needed to move the bill from the Education and Labor Committee to the floor. She accepted compromises that earlier versions had rejected. And on June 10, 1963, President Kennedy signed the Equal Pay Act into law. Peterson was there. Caroline Davis was there. Representatives of the Women's Bureau and the National Woman's Party were there. 18 years of persistence had produced a law. But what kind of law? That question matters more than the signing ceremony. Because the Equal Pay Act of 1963, examined closely, is a remarkably cautious piece of legislation. It was not written to eliminate the wage gap. It was written to survive. It was written to pass. And the distance between those two goals turns out to be enormous. The law mandated equal pay for equal work requiring equal skill, effort, and responsibility, performed under similar working conditions within the same establishment. Every one of those qualifiers mattered. Equal work, not comparable work. Same establishment, not same industry. Similar working conditions, not the same employer. The law was a series of narrow corridors, and employers who understood the architecture could navigate around it without ever technically violating it. Then there were the exceptions. 4 of them, written directly into the statute. An employer could pay a woman less than a man doing the same job if the difference was based on a seniority system, a merit system, a system measuring production by quantity or quality, or any other factor other than sex. That 4th exception, 7 words long, would become the most litigated phrase in employment discrimination law. Any other factor other than sex. It was an escape hatch the size of a highway. The law also inherited the coverage limitations of the Fair Labor Standards Act, which it amended. Executive, administrative, and professional employees were exempt, and so were domestic workers and agricultural workers. In 1963, millions of working women, disproportionately black and brown, performed exactly the kinds of labor the law simply did not reach. The white-collar exemption alone excluded a vast portion of the female workforce, and that gap would not be closed until the Education Amendments of 1972, nearly a decade later. And crucially, the burden of proof fell on the employee. A woman who believed she was being paid less than a man for equal work had to identify a specific male comparator in the same establishment, demonstrate that the work was substantially equal in skill, effort, and responsibility, and then prove that none of the 4 exceptions applied. She had to do this while still employed by the company she was suing or with the information she'd managed to gather before being terminated. In an era when discussing your salary with coworkers was grounds for dismissal at most firms, the practical obstacles were staggering. Esther Peterson understood these limitations. She later recalled a conversation with a plant manager during the lobbying effort. She'd asked why women on his production line earned less than men doing the same assembly work. His answer was blunt. We pay them less because we can get them for less. That logic, the logic of the market, was precisely what the 4th exception preserved in statutory form. If a company could demonstrate that the going rate for women in a particular labor market was lower than the going rate for men, it could argue that it was paying market price, not discriminating by sex. The law that was supposed to kill that argument had left it a door. The court spent the next decade testing where the walls actually were. In 1970, in Schultz v. Wheaton Glass Company, the Third Circuit Court of Appeals confronted a common evasion. Wheaton Glass employed male selector packers and female selector packers, doing substantially the same work. But the men were occasionally asked to perform additional tasks, and on that basis, the company paid them 10% more. The court ruled that equal did not mean identical. Substantially equal work required substantially equal pay, and minor differences in job duties could not justify a blanket differential. The decision mattered because it closed one specific loophole: the technique of assigning a man one extra task and using it to justify paying all men in that classification more than all women. 4 years later, the Supreme Court heard Corning Glass Works versus Brennan. Corning had historically employed only men on its night shift and only women on its day shift, performing the same inspection work. The men earned more because of a night shift differential. When Corning began allowing women onto the night shift in the late 1960s, it maintained the pay disparity, arguing that the historical rate structure constituted a factor other than sex. The Supreme Court disagreed. The differential had originated in a period when women were excluded from night work by company policy, and its perpetuation could not be justified as sex-neutral simply because it had existed for a long time. A discriminatory practice did not become legitimate through repetition. These cases established real boundaries, but they also revealed the law's structural weakness. Each case required a specific plaintiff, a specific comparator, a specific establishment, and years of litigation. Each victory applied to the facts of that case. And meanwhile, employers had discovered something far more effective than fighting equal pay claims in court. They could simply ensure that the claims never arose. The technique was occupational segregation, and it was not new. But after 1963, it acquired a new legal significance. If women and men never held the same job title in the same establishment, the Equal Pay Act did not apply. There was no comparator to identify. There was no claim to bring. The law required equal pay for equal work, and if the work was classified as different, the law had nothing to say. AT&T, the largest private employer in the country through the 1960s and 1970s, refined this into a system. Internal documents later exposed during an EEOC investigation revealed that the company's job classification structure was designed, in practice, to channel women into lower-paid roles and men into higher-paid roles, regardless of the actual work being performed. The roles were different on paper, the titles were different, the pay scales were different, and the Equal Pay Act could not touch it. The investigation culminated in a 1973 consent decree in which AT&T agreed to pay $38 million in back wages and raises to thousands of women and minority employees. $38 million in 1973. That was what one company owed when the actual scope of its wage practices was forced into daylight. But the consent decree was a product of Title VII of the Civil Rights Act, not the Equal Pay Act. It took a different law, with broader language about employment discrimination, to reach what the Equal Pay Act by design could not. And even that broader law had its limits. Because if the fundamental problem was not that women were paid less for the same work, but that the work women did was systematically valued less than the work men did, regardless of actual skill, effort, or responsibility required, then what? A secretary, a nurse, a social worker, a librarian. Each required education, training, professional judgment. Each was compensated at rates far below male-dominated jobs, requiring comparable qualifications. If a tree trimmer for the city earned more than a licensed practical nurse for the same city, was that a market outcome or a discriminatory one? The comparable worth movement of the late 1970s and 1980s said it was discrimination. Not individual discrimination by individual employers against individual women, but structural discrimination embedded in the entire system of job valuation. The argument was that female-coded occupations were paid less precisely because they were female-coded, and that the appropriate remedy was to evaluate jobs by their actual content and compensate accordingly. In 1983, AFSCME, the American Federation of State, County, and Municipal Employees, sued the state of Washington. A state commission study had found that female-dominated job classifications were paid approximately 20% less than male-dominated classifications, requiring equivalent skill, effort, and responsibility. The state had commissioned the study, received its findings, and done nothing. A federal district judge ruled that this constituted discrimination under Title VII. The state of Washington, the ruling said, could not commission a study proving systemic undervaluation and then refuse to act on it. 2 years later, the Ninth Circuit reversed. The appeals court held that market-based compensation, even if it reflected societal discrimination, did not by itself violate Title VII. An employer could pay market rates even if those rates were shaped by historical patterns of undervaluing women's work. The state of Washington was not obligated to correct the market. Patrick Courtain of the Justice Department called comparable worth a dead duck after the ruling. He was right in the legal sense. The comparable worth doctrine never recovered. Courts would not require employers to question the market rates they paid, even when those rates demonstrably tracked gender rather than job content. The factor other than sex that justified paying women less could be, in effect, the fact that women had always been paid less. History justified itself. So by the mid-1980s, the landscape of the law was clear in its limits. The Equal Pay Act covered only the narrowest cases: same work, same establishment, identifiable comparator. Title VI was broader, but would not compel employers to revalue occupations. Comparable worth was legally dead. And the wage gap, which had narrowed modestly through the 1970s as more women entered professional occupations, began to plateau. The tools that remained were individual: file a complaint, find a comparator, prove the work was substantially equal, prove no exception applied. Do this while employed or with whatever information you managed to retain after leaving. Do this against a company with a legal department and decades of classification precedent on its side. Do this knowing that even a victory applied only to your facts, your workplace, your specific situation. If the law would not close the gap, and the courts would not compel revaluation, and the market by definition reflected the discrimination it was supposed to correct, then what was left? What tool, what mechanism, what theory of change could address a disparity that had survived the clearest legal prohibition the country had managed to produce? By 1990, the answer was becoming visible in the data itself, not as a solution, but as a pattern. The wage gap had moved. 27 years after the Equal Pay Act, women earned 72 cents for every dollar earned by men, up from 59 cents, 13 cents of progress across nearly 3 decades, roughly half a cent per year. That rate of change tells you something. It tells you the gap wasn't frozen. Women were entering professions that had been closed to them, earning degrees at rates that matched and then exceeded men's, accumulating experience in fields where seniority translated to higher pay, educational parity, occupational diversification, the slow grinding of legal complaints and corporate settlements and changing norms. All of it pushed the number upward, but it pushed slowly, and then it pushed even more slowly. By 2000, the ratio was 77 cents. 7 cents of movement across the 1990s, a decade of economic expansion, record low unemployment, and rising wages across nearly every sector. By 2015, it was 82 cents, 5 cents across 15 years. By 2023, it was 84 cents, 2 cents in 8 years. The trajectory is unmistakable. Each increment of progress smaller than the last, each cent harder to gain than the one before it. Like a curve approaching but never quite reaching a line. Asymptotic in the language of mathematics, permanent in the language of lived experience. And here is where the conversation splits, where it has split for decades, into 2 parallel arguments about what that number actually measures. The first says, 84 cents is the raw gap, the uncontrolled number. It compares all women working full-time to all men working full-time, regardless of occupation, industry, hours, or experience. When you control for those variables, when you compare women and men with the same education, in the same job, at the same company, with the same tenure, the gap shrinks. In some analyses, to 5 or 6 cents. In others, to 2 or 3. The second argument responds, and why would you control for occupation, when the sorting of women into lower-paid occupations is itself a product of discrimination? Why would you hold hours constant when the reason women work fewer hours in certain stages of life is because the structure of caregiving hasn't changed? Why would you adjust away the very mechanisms through which the gap operates and then declare the remaining sliver the real gap? Both arguments are correct on their own terms. Both miss something the other captures. The controlled gap tells you how much discrimination operates within a given job at a given firm. The uncontrolled gap tells you how much the entire economic system, from the structure of work to the distribution of care to the valuation of occupations, costs women in aggregate. They're measuring different things, but they're measuring the same problem from different angles. And the people earning less don't experience the distinction. A woman who makes less money because she chose a lower paid field still makes less money. A woman who makes less money because she reduced her hours after childbirth still makes less money. The paycheck doesn't come with a footnote explaining which portion of the shortfall counts as discrimination and which portion counts as choice. Claudia Golden spent decades pulling that distinction apart, not to minimize it, but to understand its mechanics. In 2023, she won the Nobel Prize in Economics for her work on women's labor market outcomes, and the research that earned it centered on a specific insight about how the modern gap actually functions. The old discrimination, the kind the Equal Pay Act was written to address, was crude. It was a company paying a woman less because she was a woman, full stop. That kind of gap has mostly closed, at least within narrowly defined job categories. What replaced it is subtler and in some ways more durable. Golden identified what she called greedy jobs, roles that demand long, inflexible hours, that reward being available at all times, that pay a premium for continuity, for never stepping away, for being the person who can take the call at 9 p.m. or fly out on Sunday. Finance, law, management consulting, medicine in certain specialties. These jobs don't explicitly exclude women. They don't pay women less per hour. What they do is structure compensation so that the highest rewards flow to those who can offer total availability, and then they operate within a society where caregiving responsibilities fall disproportionately on women. The result looks like a choice. A woman chooses a more flexible role. She chooses to work fewer hours during certain years. She chooses a specialty with more predictable scheduling. But the choice is made within a structure that was never designed to accommodate the reality of her life, and the penalty for making it compounds over years, over decades, over a full career. Golden found something else, though. She found a counterexample: pharmacy. Over the past 40 years, pharmacy transformed from a profession with significant gender pay gaps into one of the most egalitarian, high-paying fields in the country. And it did so not because pharmacists became more enlightened, not because of lawsuits or legislation, but because the structure of the work changed. Large pharmacy chains and health systems standardized protocols, invested in information technology that made patient records portable, and made individual pharmacists largely substitutable for one another. One pharmacist could pick up where another left off without loss of continuity. The premium for long, unbroken hours disappeared. Flexibility stopped being penalized because the work no longer required personal irreplaceability. The gap closed not because anyone decided to close it. It closed because the conditions that produced it were eliminated by changes in how the industry organized itself. The work became, in Golden's framing, less greedy. And when work becomes less greedy, the people who can't afford to be consumed by it stop being penalized for that fact. But pharmacy is the exception. Most high-paying professions have moved in the opposite direction. They've become greedier, not less. And for many families, the calculation becomes exactly what Golden described: a marriage of equals, or a marriage with more money. Two careers demanding total availability don't survive the arrival of a child without someone yielding. The person who yields is, statistically, overwhelmingly, the woman. Not because of explicit discrimination, because of 1,000 interlocking structures, each individually defensible, collectively devastating. And then there's what happens before the choice is even made. Shelley Carell, a sociologist at Stanford, designed audit studies that sent identical resumes to employers. Same qualifications, same work history, same everything. Except some resumes mentioned membership in a parent-teacher organization, a subtle signal of motherhood. Others didn't. Mothers were rated as less competent, less committed, and were offered lower starting salaries. Fathers who signaled parenthood were rated as more committed, more stable, and were offered higher salaries than non-fathers. The motherhood penalty and the fatherhood bonus operating in tandem, not because anyone said we pay mothers less, but because in the evaluation, in the gut judgment of the person reviewing the file, a mother was already categorized differently, already worth less. And beneath all of this, the devaluation effect. When women enter a field in large numbers, wages in that field tend to fall relative to comparable fields that remain male-dominated. This has been documented across decades and across occupations: recreation workers, ticket agents, designers, housekeepers, biologists. As the proportion of women rises, compensation declines, even controlling for the skill level and working conditions of the job. The work doesn't change, the perception of the work changes. It becomes women's work. And women's work, in the American economy, has always been worth less. Not because the market discovered its true value, but because the market inherited a valuation system that was never neutral to begin with. So what does 84 cents compute to? Take median female earnings, full-time, year-round. Apply the 16-cent gap, run it forward over 40 years of working life. The number varies depending on assumptions about wage growth and discount rates, but the estimates converge in the same range. Roughly $400,000 to more than $540,000 in lifetime lost wages per woman, per median career, not per exceptional case. That's a house, in many markets. That's the difference between retiring with savings and retiring without them. And it's compounded over a lifetime, which means it's not just income lost, but investment returns never earned, Social Security benefits permanently reduced, pension accumulations that never build. The gap doesn't just take from the present, it takes from the future, and it takes more from the future than from the present because money lost early compounds longest. In 2007, the Supreme Court heard Ledbetter versus Goodyear Tire and Rubber Company. Lilly Ledbetter had worked as a supervisor at a Goodyear plant in Alabama for nearly 20 years. Near the end of her career, she received an anonymous note revealing that she was paid significantly less than every male supervisor at her level. She filed a discrimination complaint. The case went to the Supreme Court, which ruled 5-4 that she had waited too long. The statute of limitations under Title VII began running from the date of the initial discriminatory pay decision, not from the date of the most recent paycheck reflecting that decision. It didn't matter that she hadn't known. It didn't matter that the discrimination had been hidden. The clock had run. 2 years later, in January 2009, the Lilly Ledbetter Fair Pay Act became the first legislation signed by President Barack Obama. It amended Title VII to establish that the statute of limitations resets with each new discriminatory paycheck. A worker who discovers she's been underpaid for years can now file a claim without being told she should have filed it years ago, before she had the information. That's what the law changed. The clock. The procedural window. What it didn't change was the underlying pay structure, the evaluation systems, the negotiation dynamics, the greedy job premium, the motherhood penalty, the devaluation effect, or any of the mechanisms that produced the gap in the first place. It made it easier to challenge pay discrimination after discovering it. It did nothing to prevent pay discrimination from occurring. Other countries made different choices. Iceland in 2018 began requiring companies with 25 or more employees to obtain equal pay certification, not simply to self-report or disclose, but to prove through third-party audits that their pay systems could justify any differences between what men and women earned. Companies that can't demonstrate pay equity don't receive certification. The burden shifted from the employee proving she was underpaid to the employer proving its system was clean. The United Kingdom, beginning in 2017, required organizations with 250 or more employees to publish their gender pay gap data annually. Mean and median hourly pay, bonus distributions, the proportion of men and women in each pay quartile. Public, searchable, comparable. Not because publication alone closes gaps, but because visibility creates pressure that invisibility never can. Denmark has used wage statistics reporting for companies with 35 or more employees, and is now transposing the European Union's Pay Transparency Directive into national law, strengthening disclosure requirements further. These are not utopias. Each system has limitations, enforcement challenges, and gaps of its own, but they represent a fundamentally different theory of change. They locate the problem in the structure, not in the individual complaint. They require transparency as a default rather than treating pay information as a corporate secret to be uncovered only through litigation. They assume that if the system is fair, proving it should be simple, and that if proving it is difficult, the system probably isn't fair. The United States took a different path. Individual complaint, individual burden of proof, individual remedy. 62 years of it now. And the number moves like something approaching a limit it will never reach. 0.5 cents per year when it moves at all. The law that was supposed to close the gap has now existed for longer than the gap has remained open since its passage. The distance between the promise and the reality has outlasted the law itself in a way that no one debating H.R. 5056 in 1944, or celebrating the signing ceremony in 1963, or arguing comparable worth before the Ninth Circuit in 1985, could have imagined. For 187 years, the gap was legal. Written into contracts and codes and court opinions, enforced by employers and blessed by legislatures, documented by statisticians who recorded it without questioning it. Then the law changed. And for 62 years after the law changed, the gap persisted. Smaller, narrower at the margins, but persistent, moving in fractions of a cent, while lifetimes of earnings compounded beneath it. What does it mean that the people writing the rules were never the people the rules were written about? What does it mean that the law can say one thing and the economy can do another, for decades, without contradiction, because the mechanisms of inequality learn to speak a language the law doesn't recognize? What does it mean that a number can move so slowly, that an entire working life passes between 1 cent and the next? Golden called it a convergence. The word implies arrival. But convergence at this rate means a woman entering the workforce today will likely retire before the line meets. Her daughter may too. The math doesn't require malice or conspiracy. It only requires that the structures already in place continue operating as designed, that greedy jobs stay greedy, that caregiving stay distributed as it is, that the market continue pricing female-coded work the way it always has. The gap doesn't need anyone to defend it anymore. It just needs no one to dismantle the conditions that produce it. And dismantling conditions is harder than passing a law. It always has been.